The next case is Wicks versus Lovers Lane Market. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve?
3 minutes, Your Honor.
Very good. I will make note of that. I will be keeping track of time. You will note if you look to your left, it's up there on the top will be your time. When that gets to 3 minutes, you will be out of time. I'll try to let you know about a minute before that to give you a warning. And counsel, when you're presenting your time, I'll try to give you a minute warning as well. Your time is there in the middle. I'll likely just be using that top time for you for your rebuttal as well, so please kind of disregard the 5 minutes at the bottom.
Okay.
The arguments are being recorded, so when you come to make your presentation, first, please introduce yourself. Secondly, make sure you stay behind the podium. We're audibly and visually recording you, and if you move, we'll lose both those, I suspect. You should not use the name of any child, minor, or victim in this matter. If you would, use initials if you get to that point, rather than the name or some designation like victim or child. With that, we read your brief and are ready to proceed on that review.
Thank you, Your Honors. May it please the Court, my name is Ken Myers. I'm here on behalf of the plaintiff appellant Ronda Wicks, who's the administrator of the estate of Paris Wicks. This case may sound a little familiar because this is our third trip here. And I'd like to basically argue 2 points, which are the 2 assignments of error. One is procedurally, the trial court should not have entertained another motion for summary judgment after this court ruled in Wicks 1 that they had failed to properly move for summary judgment on the 3. I want to find a shorthand way of saying that negligence per se, gross negligence, and responding as superior, so I'll just call them the three claims. And so Wicks 2 was basically about the trial court misinterpreting this court's ruling on Wicks 1 and the scope of the remand. And then we're here now on Wicks 3, which is the trial court allowing a summary judgment motion to be filed despite the ruling in Wicks 1, and then granting that motion. So I'd like to argue the procedural aspect of whether it's proper to even be here on the motion for summary judgment, and then in the alternative on the merits of the motion for summary judgment, or the granting of the motion for summary judgment. So I think this court knows, and especially Judge Hansel, you've been here on all 3, that this is a very tortured procedural case. But basically what it boils down to is that on these 3 claims, summary judgment was disallowed. And so when trial court ruled the second time on the scope, this court then found that the trial court had once again misinterpreted this court's first ruling on the scope of the remand. And so we never really got to the merits, but it's been my contention all along on behalf of the plaintiff that once this court ruled the first time that summary judgment had not been properly moved for or argued, that the defendant should not get a second or a third bite at the apple on summary judgment. They had failed to move for summary judgment. That's all they get. The trial court found differently, and I think that as I've outlined in my briefs, that this shouldn't even be here. The case after the first remand should have been set for trial because there was no summary judgment on those three claims. So we've spent a lot of time procedurally coming back here a second and now a third time on something that I thought was pretty well settled the first time, which is you didn't file a summary judgment, should be set for trial. So that's my basic argument on the procedural issue. As far as the substance, the trial court found there was a lot of evidence that created genuine issues of material fact about whether there was loitering, whether there was drug use, whether there was drug trafficking, whether there was weapons, whether there were violent crimes, whether there were constant police calls. And the trial court found that that still wasn't enough because it didn't rise to the level of somewhat overwhelming, and also that the crimes that were admittedly committed, or at least there was a genuine issue of material fact about whether they were committed in and around the store, whether those were the same type of crimes as the robbery and murder of Paris Wicks. And in my brief, I pointed out several cases that stand for the proposition that in order to have foreseeability, it doesn't have to be the exact same crime. There doesn't have to have been a prior murder for the store to be on notice that there's a likelihood of violent crime. And in fact, the police reports, even the ones that the trial court admitted, showed a propensity for the exact type of violence that ended up occurring to Paris Wicks. And again, I think one of the things that the trial court did was, while saying that it was giving every benefit and every inference to the plaintiff, and only ruling on whether there was a genuine issue of material fact, it seemed like the trial court was looking for proof at the trial level of whether these things had been committed and whether the store knew about them. And I think if you take a step back and look at what the purpose of summary judgment is, it's to say, well, if a jury believes X, could the plaintiff prevail? And I think that there's so many facts in this case that if you look at it more favorably to the plaintiff, that you can certainly find that the injury and the death of Paris Wicks was foreseeable, because you had, just if you look at the surveillance video, you've got these people who had, the store knew who they were. They were, some of them, working there under the table. They were known in the neighborhood as gang members. Some of them had just come out of prison. They're hanging out at the store. They had taken over the store. But when you add to that, the surveillance video also shows huge crowds of people outside the store. And this is just the same day of the murder. But if you also look at the testimony of the store employees, who said, yeah, we had to, 10, 12 times a day, I had to shoot people out. I had to shut the store down because I was worried about things going on. We had to carry guns. There was a guy named Monster who hung out at the store. We were afraid of him. The police officer...
Do you think, based upon the trial court's decision in this third go-around, that the court was saying there's no question of fact? Or was the court saying, look, there might be a question of fact, but as a matter of law, even if there is a question of fact, you're going to lose? What direction was the court ruling to rule against?
I think that the court said there's lots of questions of fact on the path toward the standard that you need of foreseeability. But even giving you all those questions of fact, you don't quite get there because you haven't got the type of crime that needs to be committed to create foreseeability. So, and that is a bit curious to me, because the court was basically saying there's lots of questions of fact, but it's on gun possession, and drug trafficking, and things like that. And you've got to show a robbery and a murder. And that the store knew there was already a robbery and a murder, and therefore they should have been on the lookout to prevent that. And again, in the case law that I've cited, McGuillian and Walworth particularly say that you don't have to have the specific type of crime, you just have to have criminal acts. So what the trial court was sort of conceding was there was lots of criminal acts. The police were there all the time. She conceded all those types of crimes, but then she'd say, well, you still got to show me robbery, still got to show me murder, and I don't think that's the standard. And I think that's a jury issue at any rate. The question of how much foreseeability is foreseeability, I think is a pretty low threshold for the court to decide legally, and then the rest goes to a jury. And I don't have a problem arguing before a jury that all this stuff that we've shown, and that would probably be fleshed out even more at trial because you have live testimony, that's enough to show foreseeability. And the defense basically says, well, we've got all these people saying, we didn't know anything about crime, we didn't know anything about gangs or drugs. That's not, we're not here to judge credibility at the summary judgment stage, but it's like saying, the first 30 years of my life I never committed a crime, but then the next 10, I committed 10 crimes, it's like saying, all you should look at is that first 30 years. So in other words, the negative evidence doesn't negate or outweigh the positive evidence. So these guys can claim all they want that, oh, I don't know anything about gangs or drugs, but they all serve time for these things, and they're all hanging out at the store, they're working at the store under the table. The video shows what one could reasonably interpret as the manager of the store getting high with one of the defendants 5 minutes before the murder. Those are all jury questions. You know, I'm going to argue for the jury. Look at that video. What do you see? And they're entitled to see it that way, or defense can argue that was just a cigarette, or you know, whatever they want to argue. But those are issues of fact that that I think a jury is entitled to look at. And I do think that one way or another, whether it's under my first assignment of error, my second assignment of error, this case should go to trial. And I think all the evidence is there if the court wants to go to the merits, but the court could also say, you know, we ruled the first time summary judgment wasn't properly invoked. You don't automatically get a second bite at the apple. It's just not automatic that you can file that and have it ruled on. Actually, a little more than my time, but if the court doesn't have any questions, I'll sit down until my opponent speaks.
No question, thank you.
May it please the court, my name is Rich Rizzi. I'm here on behalf of Lovers Lane Market, the defendant, appellee. I'll start off just briefly addressing, I mean, there have been a lot of allegations that were just made. The problem is, and I'll circle back to this, none of this is in the record. I mean, all of this was excluded, and none of it's assigned as error on appeal that all this was excluded. So that's, I mean, the police being there all the time, they weren't there all the time. That's not in the record. But I'll circle back and go to the first assignment of error.
The police were there, some,
Yes.
in any rate. There's some evidence in police reports when they were at the Lovers Lane Market in the past. It seemed to me, as I understand, the court's ruling on the police reports coming in and taking out hearsay. Do you agree the contention, though, is that the trial court said, yes, there's some questions of fact here, but despite that, as a matter of law, you're not going to win anyway, so summary judgment's granted on that basis? Or was the court saying there's no question of fact?
Well, I think as to the legal standard, there are no questions of fact. The legal standard is somewhat overwhelming. And, I mean, what have we actually got in the record? We've got 3 police reports. I mean, that's it. I mean, based on appellant's brief, there are 3 police reports that are cited in appellant's brief that actually were partially considered by the trial court. None of them took place at Lovers Lane Market. In fact, none of the police reports actually, I don't believe, took place. Certainly none of the ones that were admissible took place at Lovers Lane Market. The 3 that were argued in appellant's brief that the trial court actually found partially admissible are exhibits 15, 17, and 28. They're all more than a year before the incident at question. One is somebody firing from a car, allegedly. The police didn't witness that, but they were called. Again, and none of this is at the market. All of this is in the area. And then the 2 others were robberies. And the other 2 were in 2011. This, of course, happened in 2013. I mean, you can look at Officer Chris's testimony. I mean, Officer Chris said that he wasn't aware of any murders, shootings, assault, or robberies at Lovers Lane or in its parking lot from 2012 through the date of Mr. Wicks' death. He had no knowledge of any criminal activity inside Lovers Lane Market or its parking lot from 2012 to the day of the incident. He was never called to investigate anything at Lovers Lane Market, and no problems with Lovers Lane Market from 2012 to the date of the incident. I mean, he did testify it's a tough area. in the vicinity of the market. But if you look at any location in that area, you're going to find the police being called to various locations over a period of years. I mean, but it's not at the market, and there's no evidence that the market knew about it or had any obligation or duty created to do anything about it. I mean, you have testimony from all the witnesses that in fact it was just a market. Everybody denied drug dealing occurring there. In the first appeal, there was this whole thing about the sale of alcohol to a minor. That has been completely abandoned because there's no evidence of that at all.
Counsel,
Yes?
do you believe, when you read the court's judgment entry, that the court found that the evidence was not substantially overwhelming?
Yes.
Okay. Is that something for the court to determine on summary judgment, or is that an issue for the jury to determine whether or not the evidence meets the standard of substantially overwhelming?
I would believe it's for the court to determine whether or not there's a duty to start with as a matter of law, especially under circumstances such as this, where there is no actual admissible evidence. I mean, there are a lot of allegations and supposition by counsel, but there's no evidence in the record. I mean, and to get to a jury and to present evidence to a jury, you need admissible evidence. I mean, almost none of the police reports are even admissible.
Is there zero evidence? Is there zero evidence? Admitted, I mean.
Yeah, yes, I would say that there is zero evidence of anything occurring at Lover's Lane Market in the record. I mean, prior to this, and zero evidence. The second part of the standard is, of course, that Lover's Lane Market need to be aware. So there needs to be evidence that things occurred, and that wasn't excluded by the trial court, which I believe it all was, and that Lover's Lane Market knew about it. And there's no evidence of that either. I mean,
So if on summary judgment you don't have the smoking gun, you're done?
you don't need a smoking gun, Your Honor, but you do need enough evidence to take it to the jury. I mean, the Supreme Court in one case said that summary judgment is to prevent the matters from being subject to the speculation of the jury if there isn't a legal question involved. And here, I mean, there really isn't a legal question involved because you need some kind of evidence of some kind of notice, some kind of prior violent crime at the market, and it's just not there. Did you have any more questions on that, Your Honor? Or?
No, thank you very much, you answered my question.
Sure. Thank you very much, Your Honor. I'll go back to the first assignment of error. I mean, this court held, I mean, the law of the case, in Dunkel, this court held that the law of the case does not apply unless there's a final judgment. I mean, the appeal in Wicks 2 didn't in any way argue that the summary judgment motion was improper. It argued that the trial court improperly excluded certain pieces of evidence, which this court agreed with and remanded it back to the trial court to consider the evidence properly, which the trial court did in a very lengthy opinion. There's been no ruling on the merits.
Trying to understand what counsel's arguing here, and it's my first involvement with Wicks, so excuse my trying to get caught up to speed. Wicks number 1 comes out. I understand that you're asserting that, they're asserting that after Wicks 1 comes out, we go back to the trial court, and you raise whole new issues that were never raised before about respondeat superior and various other things, that, hey, we want summary judgment on that too. Were those issues part of the summary judgment motion that was addressed in Wicks 1, or were there a new summary judgment on new issues that were raised after Wicks
That's, what happened in Wicks 1, and I invite Your Honor to go back and read the opinion, and we moved for summary judgment on all the claims. My understanding of the decision in Wicks 1 is that because we didn't address all the elements of those 3 claims, the court found that it was not fully fleshed out, so it needed to go back and have all the elements of those 3 claims addressed.
So that goes back, do you make a new filing, or do you rely upon the summary judgment?
We filed a new summary judgment motion, addressing all the elements of all the claims. Previously, we had addressed those claims, certain elements of those claims, but not, according to the court, all the elements of those claims. So now we addressed all the elements of those claims on remand from Wicks 1. The trial court, they submitted their evidence. The trial court ruled, granted a summary judgment again. It was appealed as to the exclusion of that evidence. It wasn't appealed as to the trial court shouldn't have considered the summary judgment we filed. That was never appealed. This court found that the trial court, in fact, should have considered the evidence, or rather, not should have considered the evidence. This court found that the trial court should have looked at it in detail to determine whether or not the evidence was admissible. In ruling on the second summary judgment motion, this court did not find on the merits on any issue. This court did not remand for trial. This court remanded for the trial court to look at the evidence, which the trial court did. We did not file another summary judgment motion after that. This is the same summary judgment motion that was issued in Wicks 2. The only difference is the trial court followed this court's instruction and ruled on the evidence.
And on Wicks 1, did the court find that summary judgment was properly granted on the merits of any issue? I know they said you didn't look at A, B, C, but was there a D out there? They said, yeah, okay, D's okay, but you gotta go back and look at A, B, C also.
That's, well, negligence, the trial court entered summary judgment in our favor on the issue of duty and breach and everything, and it was not appealed.
Okay.
So this court did not remand on that, which was, and we argued in our brief as the alternate grounds to affirm, that was adjudicated back then, and that's also one of the essential elements of all these claims. So that's
Understood.
okay.
About 3.5 minutes left.
3.5 minutes left. I can go pretty quickly through these. Negligence per se. I mean, plaintiff's argument isn't that any LLM or any of its employees violated any statute. Again, that was originally in the complaint, and throughout these proceedings previously in Wicks 1 and Wicks 2, there was an argument about sale of alcohol to a minor. That's been abandoned because there's no evidence at all. And in fact, plaintiff's brief says that violations committed by the criminal defendants. That's not LLM or its employees. Gross negligence, I've already addressed the issue of that there isn't a prior history, a somewhat overwhelming prior history of violence, violent crimes at Lover's Lane Market. That's nowhere in the record. Respondent superior. There's no allegation of any negligent act by any employee of LLM. The only allegation is that LLM was negligent by, again, circling back to the prior claim that LLM was somehow negligent. So that's, I mean, it just fails as a matter of law because it's missing that essential element. I think unless the court has any more questions, I think I will rest at that point.
Thank you.
Thank you, Your Honor.
Hello again. On the issue that opposing counsel raised early in their argument about what the trial court found, the trial court, and I'm going to quote here, which I hate to do, but I think it's necessary here, the trial court found that the police reports, and these are the ones that the trial court accepted, quote, established that there were numerous instances of loitering, drug possession, drug trafficking, and weapons possession in the area surrounding LLM, and that some of the people found to be in possession of drugs or weapons had been on LLM's premises before encountering law enforcement officers. The video surveillance raised, quote, a question of whether LLM acquiesced to loitering on its premises, whether drug transactions were taking place on LLM's lot around the time of Harris's death, and whether LLM was aware that there was drug use on the premises. So the trial court already conceded that there were issues of fact on all those issues, including whether LLM knew. The trial court then said that the species of crimes, loitering, drug trafficking, drug possession, and illegal weapons possession, and even reports of violent crime that were investigated on a semi-regular basis, that there was no evidence of robbery and murder. So again, I think this court can rule as a matter of law that what constitutes enough evidence to get to trial doesn't have to be evidence of the same crime. There were violent crimes, there were reports of violent crimes, there's a genuine issue of material fact as to whether LLM knew about them, and that should be enough. And to get to, I think, Judge Hansel's question about whether the somewhat overwhelming issue is a trial issue for the jury or whether it's a summary judgment issue, I think if you've got this quantum of evidence, that the trial court shouldn't put itself in the position of the fact finder and say, well, you know, you've got all this stuff, but it still doesn't hit the threshold for me to let this go to a jury. And in addition, as I mentioned, I think the court used the wrong standard. It's not, was there other robberies and murders? It was, are there other criminal acts? And the court has already basically conceded that there were, both by the police report, by the surveillance videos, and that LLM knew about it. And so I question defense counsel's contention that there was no evidence. I mean, that flies in the face of the very decision that they're defending, because the trial court conceded there's a lot of evidence. And so, you know, I guess the question is, where does the court draw the line? And I think that the court should err on the side of letting the jury decide, because there are so many factual issues. And that's been conceded by the trial court. The question of the specific elements of the three remaining charges, I think this court in Wicks 2 clearly, well, and also in Wicks 1, clearly didn't foreclose the ability of plaintiff to prove those three claims just because it ran summary judgment on negligence, because some of the elements of negligence per se, and gross negligence and responding superior, share elements of negligence, but there are also different elements. So I think that shouldn't be an issue. And especially on the issue of responding superior, it's not a requirement that the employees commit the crimes. It's enough that the employees, which would be the store manager and the other employee that were there, knew about all this stuff, and the negligence encompasses them not doing anything about it, and the responding superior makes them responsible for what the criminal defendants did under their watch. So with that, I'd ask the court to reverse and remand and order the trial court to set this for trial. Thank you.
Thank you. And on behalf of the court, thank you both of you for your presentation this morning. The court will take the matter under advisement and issue a decision in due course. With that decision, it will be mailed to you by the clerk of courts. It will also be available on the High Supreme Court website. With with that, the court is adjourned until our